Have you ever pondered how a simple agreement between two parties can become a legally binding contract? How does English law view this process, and what would be different if we crossed the Channel to France? Today, we dive into the fascinating world of contract law. We'll explore its intricacies, its complexities, and its unique characteristics in both England and France. In English law, a contract is a legally binding agreement that creates obligations which are enforceable or otherwise recognizable at law. It requires three fundamental elements: offer, acceptance, and consideration. An offer is a clear statement of terms. Acceptance is an unqualified agreement to those terms, and consideration is something of value given in exchange for a promise. However, French contract law, which operates under a civil law system, presents a somewhat different picture. For a start, French law embraces the principle of consent, not agreement. It emphasizes the meeting of minds, or consensus, over the exchange of promises. The focus is more on the mutual intention of the parties involved, rather than the exact terms of the agreement. In English law, consideration is pivotal to the formation of a contract, but in French law, it takes a back seat. The French law doesn't require consideration for a contract to be valid. Instead, it should be entered into freely and voluntarily, with each party benefiting from a cause, a lawful and genuine reason for committing to the contract. Furthermore, English contract law is heavily based on case law, the decisions of courts in previous cases. It means that the law evolves with each new judgment. On the contrary, French contract law is codified. It's primarily based on statutes, providing a comprehensive and systematic set of rules. And what about the remedies for breach of contract? In English law, the primary remedy is damages, the monetary compensation for loss or injury. French law, on the other hand, leans more towards specific performance, where a court orders the party that breached the contract to fulfill their obligations. To summarize, English contract law is built on the principles of offer, acceptance, and consideration, and is largely shaped by case law. It primarily remedies breaches with damages. French contract law, however, is rooted in the notion of consent and cause, is based on a civil code, and leans towards specific performance as a remedy for breach of contract. Understanding these differences can offer valuable insights, whether you're a law student navigating the complexities of international legal frameworks, a business person dealing with cross-border contracts, or simply someone curious about the fascinating world of law. So, the next time you're penning a contract or reading through an agreement, remember, the law is as much about the journey as it is about the destination.